crazy news out of California. The United States Court of Appeals for the Ninth Circuit, a 3-judge panel, has decided that they are going to literally do nothing. Do nothing for likely over a year when it comes to the case of Miller versus Bonta, which is the legal challenge on appeal from Judge Benitez's final judgment in favor of gun owners. On appeal, they're literally not going to decide the Miller versus Bonta case, which is the quote-unquote assault weapon ban case before the Ninth Circuit. Why? Because there's another case involving magazines en banc in the case of Duncan versus Bonta. This is crazy and clearly strategically designed by at least the 2 anti-gun judges on that panel, one of whom was so crazily ignorant when it comes to guns that she refers to the AR-15 as the A-15. Not a joke. I'm going to show it to you when we get back. Hey folks, I'm Mark Smith, host of the 4 Boxes Down, a proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of Disarmed, What the Ukraine War Teaches Americans About the Right to Keep and Bear Arms. All right, folks, crazy decision out of the Ninth Circuit, but this is not entirely unexpected. For anyone that has watched either my video on the oral argument in the Miller versus Bonta case, which deals with the California quote-unquote assault weapon ban. Of course, assault weapon is a propaganda term by the left for just to describe semi-automatic rifles. Nevertheless, if you saw my video or you watched perhaps the argument yourself, you saw that at least 3 of the judges were desperately trying to avoid applying Supreme Court precedent of Heller and coming up with every conceivable excuse they could to avoid doing their job, applying the Second Amendment and the binding Heller and Bruin methodologies to the case of California's assault weapon ban and striking it down as unconstitutional. So if there's something your little child doesn't want to do, they can either do a bad job of it, which is usually what the anti-gunners do when they issue crazy opinions, or they can simply not do their job at all. They simply don't do it. Well, that is exactly what this 3-judge panel, I suspect it's 2 of the judges, I don't know what Judge Miller said, who is a Trump appointee, but what this panel has just decided to do is they've now entered an order so they are not going to make any decisions until the en banc case of Duncan versus Bonta, which is a challenge to the magazine ban in California, those magazines that hold more than 10 rounds, until that is decided. And then they will pick up their pens and pencils again and redeliberate the Miller case. If they were going to do this, why did they bother having the oral argument? And also, why didn't they ask for a briefing on this? Like we've seen in other cases. Like if a court is thinking about staying a case, which means to put it on pause or put it on a shelf pending some other outcome, why did they ask the parties to submit a brief or letters on this? It doesn't appear that any of that occurred. So it seems like this is just made up sua sponte by this court to get away from having to do their job, which is inconsistent with the entire purpose of the lower federal courts, which is often to allow, according to the Supreme Court, 1,000 flowers to bloom, where you have different judges with different perspectives deciding the same issue in different ways, perhaps, and that allows, when the case ultimately gets to the U.S. Supreme Court, the benefit of differing views. But here is an example where this 3-judge panel, I suspect this is 2 anti-gun judges plus Judge Miller, have decided to go forth and simply dodge the metaphorical bullet. Let's just talk about this panel and let's talk about why they may have decided what they were doing or why they decided what they did here. The first judge is Judge Marcia Berkson. She is an arch liberal, well known. She specifically wrote a separate opinion before the Nyserpa versus Bruin case that literally attacked the text, the history, and tradition test. She wants interest balancing all the way, and the government wins all the way, all the time when it comes to our Second Amendment rights. So Judge Marcia Berkson, who's the same judge who, let's just think about how your rights depend upon Judge Marcia Berkson's views. Let's just go to how she describes an AR-15. Roll the tape. You're not going to believe what you're about to see right now.
There's a lot of material in the record about other characteristics of the A-15s. That's what we're talking about, right?
The AR-15 and generic AR platform rifles.
That's right. There you have Judge Berkson doesn't even know we're talking about AR-15s, and she is responsible for protecting your rights. For those of you that put comments below that says we cannot put our faith in the judges when it comes to protecting our rights, there is some truth to what you say. But right now, of course, we must put our trust, at least in part, into the faith of judges, as well as legislators and other people who are willing to listen to rational argument about the importance of armed self-defense to thwart all forms of tyranny. And if you ever want to see how this panel was desperately trying to avoid doing its job, take a look at this question, this urging by the second judge, who also appeared very anti-gun, no surprise there. Judge Jacqueline Nagayan is an Obama appointee. Judge Nagayan is the judge who was desperately trying to find an excuse not to have to make this decision. Here is how she's pressing, believe it or not, she's pressing the state of California the state of California's lawyer, please, please, please give us an excuse to send this case back so we don't have to actually do our jobs and make a decision. Look at how she's begging the California lawyer to give her any hook whatsoever to send the case back down for more fact-finding, even though there was robust fact-finding already in this case in Miller. Thousands of citations were considered by Judge Benitez as he ruled in favor of the Second Amendment, including a comment he made at one point that says that the anti-gun judges, or I should say the state's experts, you can probably characterize them as pro-gun control, I suspect. I don't know all the state's experts, but Judge Benitez would describe the state's experts, meaning California's experts in support of the gun control laws, have been studying gun laws for over 20 years. And yet here you have Judge Nagayan saying, hey, isn't there more information needed before we have to do our jobs? Shouldn't we send it back to Judge Benitez for more time to click off the tongue, hoping and hoping and hoping that the Supreme Court that's currently constituted changes? Take a look at this Q&A and you'll see exactly what I'm saying.
Is the record fully developed in this case? I appreciate and recognize the fact that the Seventh Circuit case of Bevis was in a different procedural posture because that was a preliminary injunction stage, but at one point in the opinion, the circuit said that there could be some development of the record that would aid in the court's view as to whether an AR-15 is closer to an M16 or whether it's closer on the other line. You've had multiple opportunities to brief and present evidence. The district court, in the state's view, have you put everything that you've got on the table there?
With respect to the threshold inquiry about whether these regulated weapons are self-defense weapons, we do think that we've established a robust evidentiary record showing that these weapons are not weapons of self-defense and that they are like the M16 and similar weapons that the Supreme Court has indicated may be banned because of their offensive nature and characteristics. So while I appreciate that the Bevis decision in the Seventh Circuit was on a preliminary injunction posture, the court was also examining a similar body of evidence as the one that we have developed in this case.
Right, and that's why I asked that question, because the Bevis court did say that, for example, better data on firing rates may change the analysis, and the district court should or the district court doesn't have to, but it's free to kind of look at that again because of the reloading that's necessary in order to really make both of these weapons work. So I wondered if there was, in the state's view, a similar potential gap in the evidence that the state could fill, or whether you've, with the multiple opportunities you've had, have put it all out there and that we're only going to address the merits question here.
So the Bevis court did identify some potential areas for further factual development, but it's notable in this case that the plaintiffs have not developed any facts to fill those holes. The plaintiffs have not shown that the regulated weapons, including pistols and shotguns, for which they offer barely any evidence at all, they have not shown that the assault weapons being regulated are not like the M16 or similar weapons and are not offensive military weapons. So the evidentiary record as it exists, the record developed by the parties jointly in this case, is not materially different from the Bevis record. And we think that the record does show that at the threshold stage and the historical stage of the Bruin Standard, the assault weapon restrictions are constitutional.
So you can already see how the judges were trying to delay and avoid doing their job again. And here is the actual order. And then I'm going to say why I think the order is simply wrong. The order in Miller versus Bonta, ordered by the three judges, states, quote, "This case shall be held in abeyance and submission is withdrawn pending resolution of Duncan versus Bonta. The stay entered on October 28, 2023, which means that all you gun owners in California get to continue to go to prison, shall remain in effect pending further order of the court." That is what this court said. So that was the court order, but it's clearly wrong, and here's why I think it's wrong. I'm actually going to, because it's my job to make you the smartest person in the room, I'm going to show a great powerful language that was submitted by Second Amendment lawyers in another case in New York not that long ago, in a case called Lane versus James, which deals with, of course, as you know, the New York quote-unquote assault weapon ban. This was the submission submitted on behalf of the Second Amendment plaintiffs, and this is the sort of thing that should have been allowed to have been submitted in the case of Miller versus Bonta, but the three-judge panel never asked for the submission. Maybe it would have changed their minds. I doubt it, given where I think that panel is, at least two of the judges, but nevertheless, this is the kind of powerful language and argument that had the potential to save grace and protect gun owners in California by expediting the decision and not delaying it. This was the argument made by the Second Amendment plaintiffs to speed a case along and not slow it down. There are several reasons why a stay should be avoided under these circumstances. First, the Second Amendment right to keep and bear arms is a fundamental right, which protects an intangible and unquantifiable interest in personal protection and self-defense that cannot be compensated by damages. The loss of plaintiffs' rights is irreparable. Here, plaintiffs' fundamental rights are being infringed by defendants, meaning New York's, by defendants' enforcement of New York state laws, and it is inequitable to require plaintiffs to endure a prolonged delay in vindicating their rights. So the point is that these kinds of arguments were never allowed to be made to the Ninth Circuit panel because they never asked for it. Now, it's true that there is some relationship between the legal principles set forth in whether or not you ban magazines, which is a form of arm, versus whether or not you can ban AR-15s or semi-automatic rifles. But again, you go back to the notion of percolation, which is how the Supreme Court views lower court decisions. They want as many decisions as possible to be considered to give them the right result. Now, in this case, it should be very easy because there really is only one result. The Supreme Court's already decided how to handle arms ban cases in Heller. And until the Supreme Court gets one of these cases back up there on a final judgment, I think we're going to have to suffer through this craziness and this terrible, to me, this terrible process, which I think is utterly pathetic, that people can go to prison in places like Illinois, Maryland, and California for what is clearly an unconstitutional law. And we hope that the Supreme Court will have the opportunity, and this is the key, we need the Supreme Court to have the opportunity to take a case, one of these quote-unquote assault weapon cases, on the merits in a final judgment and not on interlocutory basis, which they generally hate to get involved with because they don't feel like their record's complete and they don't want to miss anything. So until we have a final judgment in one of these assault weapon cases, again, propaganda terms, semi-automatic rifle ban cases, I think we're going to be stuck with this kind of situation, which is unfortunate, but that's where we are. So anyway, well, I wish I could bring you better news, but this three-judge panel, if you saw any of the argument, you'll see, you know, it's pretty clear that we weren't going to do very well with this. I was predicting a 2-1 loss, but now they're just going to delay this. And as to timing, I'm guessing the Duncan case will be decided in a year, and this will be decided who knows how long after that. So a long way to wait as far as I'm concerned, as far as I can see in California. Not good news, but that's the reality on the ground as best I can tell. Because as I've told you before, I think these anti-gun judges all across America are desperately trying to delay, and hope that the current composition of the Supreme Court changes so they can replace Justice Alito or Justice Thomas with another Brown Jackson. That is the harsh reality on the ground. That is my professional view, is exactly what's going on here. And the odds of me being wrong is about, I would say, 0. That is the game that's getting played. And you all just need to understand this. And it's unfortunate that these quote-unquote semi-automatic rifle bans are percolating up in the terrible anti-gun blue jurisdictions with terrible anti-gun blue judges by and large. So they know how this game is getting played. Let us hope everyone holds on and things work out in the end. But right now, that's where we are. All right, folks, hope you learned something here today. Make sure you subscribe and resubscribe to this channel. Feel free to check out my other video on the oral argument right here if you want. I'll put a link to it. And don't forget to follow me on X at 4Boxes Diner. And we will see you again soon here again at the 4Boxes Diner.
Orders up. Table 2A.